All right, hi, and welcome back, Attorney Steve Vondra, and thank you for watching another exciting video in our Litigation Whiteboard series. In this video, we are talking about civil assault, what some people call assault and battery. We're going to tell you about the difference between the two and let you know more about this tort than probably anybody else will ever tell you, more than most people will ever know. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so here we are, and this is general legal information only, as are all my videos, not legal advice. If you have specific questions, you've been beat up, or you're being sued for civil assault and battery in California and Arizona, our two states, give us a ring. You know where to find us on the web at attorneysteve.com. But we are talking about the elements of civil assault and not criminal assault. Criminal assault is, of course, another branch of the law. You can be charged with civil assault and criminal assault. Okay, so when you get all jacked up and you go out to the parties and you're like, I'm having a good time, having some drinks, getting crazy, you know, I want to have some fun, I got some pent-up issues, I want to let my anger out tonight. Be careful, because you can get your pants sued. You can get your pantsuit off, okay? So let's go and talk about this, assault and battery. Some people say this goes together like ham and eggs. Ham and eggs, okay? If you ever had breakfast, ham and eggs. So what are we talking about? The assault is putting someone in imminent apprehension of a harmful or offensive bodily contact. So we have here HO, harmful or offensive bodily contact, putting someone in imminent apprehension. So you walk up to someone and you say, I'm just gonna knock your head off. And they go like, whoa, holy cow, what's going on here? Settle down, Tonto. You're going crazy. So that can be an assault, and that separately can be actionable. Now, usually when we're talking criminal law, I'm not a criminal lawyer, but if you get into somebody's face and you assault them and you get out and you don't actually touch them, you know, that can still be assault. But, you know, for the most part, what prosecutors are looking for is the actual contact, the harmful or offensive bodily contact, okay? Knocking someone to the ground, knocking them out, you know, being the tough guy, knocking them out. So that is the battery part. That's the ham and eggs part, the battery, okay? And this is really what's going to get people, that's going to land people in court. Assault could, I'm not saying it couldn't. Civil assault, and there's criminal assault. I don't know too many people that get prosecuted just for a criminal assault. But when you have the battery that goes with it, knocking somebody on their butt, you got fists of steel over here. Remember Robert Duran, fists of steel, back in my time? So I'm dating myself here, but back in my time. But this is an intentional tort. This is not negligence. This is not strict liability. This is when you intend to commit a battery, okay? And I think as they're looking back, there's about 7 intentional torts. This is one of them. This is bar testable. You're always going to find this on your bar exam. Somebody making some kind of contact with the other person. Now, it's not always going to be this obvious. That would be too simple, right? But before I go into that, let's talk real quick about the elements. If you're taking your bar exam and you're saying, Attorney Steve, just give me the elements, would you? Stop talking already. Just give me the elements. Okay. The elements of a battery. Now, this is from California, but I think you could check in your state. They're probably pretty similar. The touching with an intent. There has to be some sort of contact with intent. You intended to do it, or you had knowledge with substantial certainty that the touching or the harmful or offensive conduct was going to occur. So it is an intent tort. This is not negligence. This is not strict liability. You intend a harmful or offensive contact. Now, obviously, putting someone on their back, that's harmful and that's offensive. So, but notice here I circled this. It's or. It could just be offensive. You could spit on somebody's shoe in a public place and somebody goes, what the hell are you doing? Why are you spitting on my shoe? Are you just a nut job? That could be actionable as the tort of battery, okay? So we have here civil assault. When I'm saying that, I mean civil assault, battery, the whole thing, okay? Lack of consent is the next element. If you consented to touching, you know, if you said, hey, I'm hitting, throw it at my head. Go ahead, throw it at my head. You know, come on. You're consenting to that, okay? And harmful or offensive contact occurs, and the reasonable person, this is where in law, this is why you go to law school if you love philosophy, human nature, psychology. what would the reasonable person do? The reasonable person has to be offended or feel that it was harmful, okay? The reasonable person standard. I'm going to do a video on this because I want to delve into this. It's a fascinating topic. It's one of the things I loved about law school. But there's your elements, okay? So if we take this, we go, boom, there's your elements of the tort. It is intentional, and it's designed to protect the freedom from unwanted, harmful, or offensive bodily contacts, the freedom from unwanted contacts, okay? Now, when we talk about a touching, two things I want to talk about, touching and offensive. This is the third one. That's another video, okay? Make sure you subscribe. I don't know any other attorneys that are giving you the nuts and the bolts, but make sure you subscribe, okay? So touching does not have to be just the fists of war, okay? The fists of war. It could be something where you're throwing something. You could throw an object. Like you could, if you throw a Frisbee and you try to hit somebody in the head, you're intending to do that. That's assault. That's battery. That's battery when it's hitting them, okay? Throwing water, spitting on their shoe. Somebody's leaning on their umbrella. You come over and you kick the umbrella. I don't mean to be telling you all these things, but things I remember from law school. You kick the umbrella, the old person falls down, okay? So things like that can be, you can make yourself liable for a tort, okay? So again, in criminal law, you're going to need a higher standard of mental state. You're going to need to really want to do some damage to somebody, okay? So here's an example. For criminal battery, criminal assault and battery, is you're in the tip-top shape of your life and you want to go beat up some old man at a bar. You say, yeah, I don't like that guy. I don't like that guy. I'm in a bad mood. They cut my hours at work. I'm going to go take him down, just because. I don't like how he looks. So you go over and you beat the tar out of him. Because there's such a discrepancy in the body, the physical body size, this person could be liable for a crime. Now, if you accidentally kill that person, and I'm saying accidentally, if you know that you're going to be trying to do something like that, you could end up in jail for like a long time. It's called criminal assault and battery, okay? So when you go out on the town at night, be cool, be calm. Don't come out with your rage. If you have rage, stay home. Do yourself a favor, just stay home. All right, let's get back to where we are. So third-party things, such as throwing a Frisbee, throwing a football at somebody, those kinds of things can create a battery, a civil assault and battery, okay? Now, let's talk real quick about damages. Like a lot of things in law, you're going to get your full range of damages. You have hospital bills, you have pain, you have suffering, out-of-pocket costs. You have also the potential, this could kill you. This could really, literally cripple you financially. Punitive damages. What are punitive damages? Damages that are designed to punish and deter. And if you have a lot of money, this can get you. This can get you, okay? So if it's malicious, it's particularly malicious, this stuff over here, getting crazy, doing weird, crazy things. This could hit you so hard in the pocketbook, you'll wish you never would have done it. So just bear these things in mind before you go out for the evening, okay? So there's your damages. You have the full range of damages. Potential defenses. Okay, so again, consent. If you consented to something. Now, here's another way that batteries pop up. So you go into the doctor and you say, okay, there's something wrong with my gallbladder. And you say, doctor, you have my consent. You fill out the form. You have my consent to remove my gallbladder. Doctor goes in, he opens up, he says, woo, wow, the liver's not so good, the kidneys are bad. I'm going to take out the liver too. You didn't consent to that. You consented to the gallbladder. So consent has to be informed consent, as we say, and it has to be within the scope of consent. Okay, so if somebody's going outside the areas of consent, it's deemed harmful or offensive, intentional. Now we're back at the tort, okay? We're back at the civil tort and potentially criminal if it's bad enough. All right, self-defense, as we know, self-defense and the defense of others, reasonable third-party defense of others, has to be reasonable, objectively reasonable, okay? You can't say, well, I was just beating the hell out of him. I thought I was saving the old lady across the street. It's got to be objectively reasonable. If it's not, no defense, okay? Assumption of risk, AOR, assumption of risk is not a defense where you say, well, you were there at the bar, you assumed the risk of getting beat up that night. No, that's not going to work, okay? Contributory negligent. Well, you were there sitting at the bar drinking. You were getting drunk too. You were stupid. You were drinking and you were listening to a country song so I beat the hell out of you. That's not going to be a defense, okay? And finally, we have the transferred intent doctrine. So if you intend to beat this person up, right over here, you intend to clobber them and you miss and you accidentally hit the person behind them, just because you didn't intend to get them, because you intended this, your intent is transferred, okay? This is bar review stuff, baby. Transferred intent, okay? Yes, it works on the tort of battery, okay? So there you have it. This is what we're talking about, assault and battery. It can be basic civil. It can be really bad and criminal. And the worse that the damages are, the worse off you're going to be. And with a punitive damage clause and potential criminal ramifications, guys, girls, just go out, have a good time, be careful, don't get triggered by nothing or the dumbest things, or you could end up in court fighting for your life, fighting for your financial wherewithal, okay?